Policy which the Constitution commands should be fundamental in the governance of the country, require the state to direct its policy towards securing to that citizens adequate means of livelihood. The mandate in Article 39 is as importance for the state aim to maintain individual freedoms. It is always a continuous endeavor of the state, having the common good of the people at heart. So to harmonize the directive principles and the fundamental rights that, so far as property rights are so concerned, the unlimited freedom to hold it would have to undergo an adjust and to the demands of the state policy dictated by the directive principles. The attribute of scaredness of property vanishes in an egalitarian society. Once this is accepted and deprivation and expropriation are cognized as inevitable in the interest of a better social organization in which the reality of liberty and freedom can be more widely achieved, the claim made on behalf of property that it is an immutable natural right loses force. Nor is it correct to describe the fundamental rights, including the right to property, as rights reserved by the people to themselves, what the Constitution confer. Red was made revocable if necessary by the A1 mandatory process, pp. 593 to 596, 600 to 603. No implied limitations, C, and be inferred from the preamble. The preamble is a part of the Constitution and is amendable under Article 368. The Subi N1 issue that the fundamental rights are an elaboration of the preamble is an overstatement and a half-truth. Most of the fundamental rights may be traced to the principles of liberty and equality mentioned in the preamble. But whereas the concept of liberty and equality are mentioned in absolute terms in the preamble, the fundamental rights, including the several freedoms, are not couched in absolute terms. They reflect the concepts of liberty and equality in a very attenuated form, with several restrictions imposed in the interest of orderly and peaceable government. The preamble read as a whole does not contain the implication that in any genuine implementation of the directive principles, a fundamental right will not suffer any diminution. Nor is there anything in the preamble to suggest that the power to amend the fundamental right to property is cut down. The preamble, it is no well settled, can neither increase nor decrease the power granted in plain and clear words in the enacting parts of a statute, p. 609 to 613. A constitution is an organic instrument continuously growing in utility, and the question of its repeal never arises as long as orderly change is possible. Kesavananda Bharati, Palekar, J. 47. It is the nature and character of the Constitution as a growing, organic, penna elevenant, iovikerkine instrument of government which exclude the repeal of the Constitution as a C, and not the nature and character of the amending power, p. 619. If it is the court that is keenly to decide what are the essential and non-essential provisions, what stable standard will guide the court in deciding which provision is essential and which is not essential. The difficulty assumes PTR proportion when an amendment is challenged on the ground that the core part of an essential feature is either damaged or destroyed. Apart from the difficulty in determining where the core of an essential feature lies, fantastic faults may follow in working the Constitution. The court cannot benefit to determine the spirit of the Constitution when concepts of social or economic JD, stick arc, offered for our examination in the interaction on provisions or clattering to right to property, mankers traditionally left to legislative, policy and wisdom, we are bound to flounder in labyrinths to the character of which we have in Kenuflicicant Gillets, 620-022, on a conliteration, therefore, of the nature of the amending power and the unqualified manner in which it is given in Article 368 of the Constitution, it is impossible to imply any limitations on the power to amend the Foodum. Santal writes, since there are no limitations express or implied on the amending power, it must be conceded that all the amendments which are in con must be deemed to be valid. The court cannot question their policy or talir wisdom. State of Behizar Foiderv. Kameshwar Singh, 1952, SCR 889, Ryan v. Lennox, 193H Irish Jepperts, 170, Moore v.I., Attorney General for the Irish Stat, Dive J1C 484, Warburton 5. Loveland, 1831, 2 Dow Clark 480 Bentley. Arpther 1876-77, or CHD 588, 592, Reg Fibura, 1878. 3. Apcas, 8. Attorney General for the Province of Ontario, O v. Attorney Gen. Al for the Dominion of Canada, 1912. Apcas 571. Webb v. Outrim, 187. AC, 81. The Amalgamated Society of Engineers v. the Adelaide Steamship Company, Limited, RMD Oars, 28. CLR 129. The Berubari Union and Exchange of Enclaves in 1960, 3 SCR 250 and Secretary of State V. Maharaya of Babali,